Hello, this is Vicki Lubin. I am Compliance Consultant and Outside Counsel to FactRight. Before we begin reviewing the SEC amendments to Reg D, I just want to mention that this is information. It's not intended to be legal advice, but it's information we believe to be accurate. I'll be paraphrasing some of the provisions of the new rules, and so you still need to seek legal counsel on exactly how they apply to your company and business. Before we begin reviewing the amendments, let's revisit the current rule 506B that really was the focus and the subject of the amendments the SEC made. Rule 506B is the most widely used exemptive rule for limited private offerings under Regulation D. In the U.S., securities either must be registered with the SEC before they're offered or be offered subject to and in compliance with an existing exemption under the securities laws. So under 506B, the conditions on the offering were that there was no limitation on the amount, but the offering could only be made to accredited investors and up to 35 non-accredited sophisticated investors. The additional condition of Rule 506B that really is a major restriction of those offerings is that no general solicitation or general advertising by the issuer or those acting on its behalf is permitted. So there can be no advertising in publicly available media such as TV, radio, newspapers, unrestricted websites. The terms general solicitation and general advertising are not defined, but within the rule 502C that includes that prohibition, there is the guidance on what general solicitation would be, and it's those sorts of things that I just mentioned. Now, the SEC didn't change Rule 506B itself, so that still exists. That particular limited exemption from registration is still available, and issuers can still rely upon it and make offerings pursuant to 506B. So some issuers may continue to rely on that provision for new offerings and for pending offerings. But the SEC added a new provision to Rule 506, Rule 506C, and it's being referred to as the General Solicitation Amendment. It provides for a new exemption from registration, which allows general solicitation and general advertising, provided certain other conditions are met. There is no limitation on the offering amount in a private offering under new Rule 506C. We'll talk further about the specific conditions of 506C shortly. Another amendment that was made is to add new bad actor disqualification requirements to Rule 506 offerings. This new rule is set forth in 506D, and it provides that an issuer is disqualified from relying on a Rule 506 limited offering exemption, i.e. either B or C exemption, if the issuer or certain others involved in the offering are subject to a disqualifying event that occurs on or after September 23rd, which is the effective date of the bad actor amendment. New Rule 506D specifies who's covered in addition to the issuer and specifies those sorts of events that are considered disqualifying events. In addition to the bad actor disqualification rule, which provides that it applies to disqualifying events that occur on or after September 23rd, the SEC added another new rule, 506E, that mandates disclosure by issuers of disqualifying events that occurred before September 23rd, 2013. And again, it's those disqualifying events that are set forth in Rule 506D. And we'll talk in more depth about those amendments as well. So let's talk further about Rule 506C, the exemption that now permits private funds to use general solicitation. The conditions of that exemption are all purchasers must be accredited investors. And that definition, accredited investor, is unchanged from the rule that existed before 506C. The issuer has to take reasonable steps to verify accredited investor status. Reasonable steps is not defined within the rule, but as I'll tell you more about shortly, the SEC provided some guidance about actually reasonable steps is defined for natural persons, but not in an exclusive manner. The other conditions are that the issuer must meet all requirements of Rule 501, which includes the definition of the accredited investor term and other definitions, and as I mentioned, that hasn't changed. Rule 502A that provides for some complex integration rules about successive Regulation D offerings, and Rule 502D, which has resale limitations. So those are the conditions of Rule 506 offerings. You can make offers only to accredited, and sales only to accredited investors. You can use general solicitation. Again, that's not defined. And you have to meet those other technical requirements. What does general solicitation and general advertising mean? What can you do under new Rule 506C if you're an issuer or acting on behalf of an issuer? As I said, there's no definition of general solicitation and general advertising in either 506C or within 502C, that rule that included the prohibition for 506B offerings. But 502C suggests that general solicitation would include any advertising in public media and the use of unrestricted websites. So 506C offerings can involve general advertising and publicly available websites. However, in the end, a sale can only be made to an accredited investor, and in addition to that condition, the issuer has a duty, which is a new duty, to take reasonable steps to verify accredited investor status. Now, the rule does not mandate specific steps, but in the adopting release, the SEC provided guidance about what sort of approach to determining accredited investor status would be reasonable. And the SEC articulated sort of an analytical approach that would be interconnected and would involve considering the following relevant factors: the nature of the purchaser and the types of accredited investor the purchaser claims to be, the amount and types of information the issuer has on the purchaser, the nature of the offering and the terms of the offering, such as the minimum investment amount and how the purchaser was solicited. Now, those factors need to be considered in an interconnected way, so depending on what you got in terms of facts and information for one factor, you need to figure out what you need for the other factors and consider all of them together and determine if, based on all those facts, you have an accredited investor. Now, a lot of commenters encourage the SEC to adopt a sort of a safe harbor test or set of steps that issuers could rely upon to know that they had taken reasonable steps to determine accredited investor status. The SEC declined to mandate steps, but they did include 4 non-exclusive methods for verifying natural persons are accredited investors in the rule. So these are methods that can be used for determining that individuals are accredited investors. And if you do use any of these steps, then you should be complying with the reasonable steps to determine accredited investor requirement of Rule 506C. So the 4 methods are verifying income, and there is additional guidance the SEC provided about how you go about that. It includes looking at returns for the individual or individuals if they're joint purchasers for the past 2-year period, and then being confident that the income for the current period is likely to be the same amount. Verifying net worth, and there are different forms of documents that can be relied upon to do that. For verification by a third party, and the rule specifies that the third party would need to provide written confirmation of accredited investor status and provides that broker-dealers, registered investment advisors, licensed attorneys, CPAs, or other third parties that have taken reasonable steps to verify accredited investor status are acceptable. And that has to have been done within the last 3 months. So even though the rule specifies broker-dealers, RIAs, and licensed attorneys and CPAs are acceptable third parties, it also provides that other third parties that have taken reasonable steps could perform this third-party verification process. The last of the four methods for individuals is certification by an accredited investor who already has invested in the same issuer's prior 506B offering before the effective date of Rule 506C. And there will be quite a few people that could theoretically meet that criterion. The next rule that we're going to review in a little more depth is the bad actor disqualification set forth in 506D. Under 506D, there can now be no bad actor event applicable to the issuer or other covered persons involved in the offering, or the issuer can't rely on Rule 506. So 506D says if there are any of those bad actor events that apply, no ability to offer under Rule 506 is available to the issuer. The issuer will not lose the Rule 506 safe harbor if it properly performs the analysis of whether there was a bad actor event and can show that there's no way that in the exercise of reasonable care it could have known of the disqualifying event. So, for example, if someone lied or failed to disclose the event, even though the issuer took reasonable steps to try to confirm whether the disqualifying event existed, the issuer could be off the hook, but it would still impact the offering. They'd have to take some steps to disassociate with the bad actor. Now let's look a little more closely at the persons that are covered by this bad actor disqualifying rule and the types of events that trigger disqualification. So the persons covered by the bad actor rule are the issuer, any predecessor issuer, and certain affiliated issuers, any director, executive officer, or other officer participating in the offering, or a general partner or managing member of the issuer. Beneficial owners of 20% or more of the issuer's voting equity securities based on voting power. Any promoter connected with the issuer at the time of the sale, and promoter is a defined term. It involves people that are founders or founders and have certain holdings and are helping to sell the issuer securities. Other covered persons include a person that has been paid directly or will be paid directly or indirectly for soliciting purchases in the offering. Those are considered compensated solicitors. And then any directors, executive officers, or other officers participating in the offering, or general partners and managing members of any such compensated solicitor. Investment managers of issuers that are pool investment funds, their general partners or managing members, and such investment managers, general partners or managing members, directors, executive officers, and other officers participating in the offering. So those are the categories of covered persons. The disqualifying events that such persons cannot have had, or they'll be considered bad actors, and then the issuer can't rely on, can't use them in the offering, are as follows. And I'm not going to read every word, but criminal convictions within 10 years before the sale, or for issuers 5 years. And those are convictions in connection with purchase or sale of security, or with filing false statements with the SEC, or arising out of certain conduct of SEC-regulated entities. Court orders or injunctions that relate to the purchase or sale of security and arise out of the conduct of being an underwriter or an SEC-regulated entity that were entered within 5 years before the sale. Final orders of certain state regulators that bar or prohibit the person from associated with an entity that's regulated by the state regulator. And that involves entities that are engaged in securities, insurance, banking, or savings associations or credit unions. And it would involve orders based on unlawful, fraudulent, manipulative, or deceptive conduct. And those would be orders entered within 10 years of the proposed sale. SEC disciplinary orders that suspend or revoke registration as a broker-dealer, municipal securities dealer, or investment advisor, or limit the activities, functions, or operations of a covered person. And then I'm not going to read every one of these, but there are a number of other disqualifying events that you'll see on this slide. Events that relate to registration statements that are subject of a stop order or a pending matter to determine whether a stop order should be issued is another. An SEC cease and desist order that relates to fraudulent activity as defined in Section 5 of the Securities Act or other provisions of the securities laws. Suspension or expulsion of membership from an SRO like FINRA. And false representations associated with the U.S. Postal Service within 5 years of proposed sale. Now, these disqualifying events and covered persons are very similar to bad actor provisions of Reg A, a certain rule of Reg A, and that is deliberate. The SEC was required by Congress to include disqualifying events and covered persons similar to those included in Reg A. The SEC did expand slightly the covered persons and disqualifying events in Rule 506D as compared to Reg A, but it tracks pretty closely with it. So again, before we move on to 506C, the point of the bad actor provision is that Congress wanted to make sure that issuers who had bad actors in their ownership or management or were associated with other types of covered persons like investment managers or solicitors who had bad actor events in their history could not rely on the limited exemptions from public registration under Rule 506. So that is the situation going forward, and it really does raise the question of what will be the impact on issuers of this new condition. They're going to have to go through a great deal of due diligence to determine if anybody that is involved in the issuer or those associated with the issuer has a disqualifying event, and such persons cannot continue to be associated with the issuer if the issuer wants to make offerings under Reg D, Rule 506. So in addition to 506D, the issuer has to furnish disclosure of bad actor triggering events that occurred before August 23rd to potential investors. That's a new affirmative obligation, and there's not a mandatory form or language to be used, but it's got to be a sufficiently prominent disclosure that that the investor, prospective investor, understands it and has a chance to read it. In addition to the final changes that are effective September 23rd, the SEC has proposed some additional changes to Reg D, and they're pending and in the comment period right now. They're listed here, and they include a requirement that an issuer couldn't rely on Rule 506 to make an offering for a year if they had failed to meet Form D filing requirements. Form D is the form that has to be filed with the SEC before you begin an offering under Rule 506. This proposed rule change would require that issuers file Form D with certain new information 15 days before they begin engaging in general solicitation if they're doing a 506C offering. And they also require filing of Form D within 30 days of closing any 506 offering. In addition, there's a new proposed Rule 509 that would require issuers include certain legends and disclosures in their general solicitation material used in 506C offerings. And the issuer would be disqualified from relying on 506C if it fails to do those disclosures. And this is the most significant, I think, requirement. There's a proposed temporary Rule 510P that would require general solicitation material to have been filed with the SEC on or before its first use. And as importantly, the amendments would apply Rule 156 to general solicitation used in a 506C offering. So there'd be new exposure in addition to the other anti-fraud provisions to the issuer if it doesn't comply with Rule 156. So let's now that we've reviewed the changes, take a look at the implications for issuers. We're going to spend less time on the implications for issuers and more time on the implications for broker-dealers because this webinar is really aimed primarily at broker-dealers. So some of these probably seem obvious, but there are new compliance burdens and business impacts on issuers. They have to take reasonable steps to verify that covered persons haven't been involved in disqualifying events and make sure that no bad actors participate in the offering or the exemption will be lost. And the consequence of losing the exemption is that investors have rescission rights, so that's something that issuers simply can't take the risk on. In addition, there's a new compliance burden of satisfying the disclosure requirements related to covered persons with disqualifying events where the event occurred before September 23rd. So along with the private placement memorandum and other information used in general solicitations, the issuer has to provide this disclosure. Issuers need to decide whether to rely on 506B or C for a new or existing offering. Issuers can decide that for a 506B offering that is still underway, they want to elect to convert the offering to a Rule 506C offering by filing Form D. But they will then have to comply with all the conditions of 506C for sales made from that point forward. As we discussed, 506C requires that the offering be limited to accredited investors and that the issuer take reasonable steps to verify the accredited investor status of each investor. And then the issuer in a 506C offering must ensure that it's the general solicitation and general advertising used complies with the anti-fraud provisions of federal and state securities laws. And issuers are going to want to consider the proposed Regulation D amendments that will impose, if they're adopted, additional burdens, including some additional Form D filing requirements and pre-filing general solicitation and general advertising with the SEC, and ensuring that it complies with Rule 156. So now let's focus on the implications for broker-dealers of these amendments. Kind of taking them sequentially, one of the things that broker-dealers will need to do is to include in their due diligence on a particular 506C offering, due diligence on whether and how the issuer is complying with Rule 506C. So, for example, additional due diligence will be needed to determine what the issuer is doing to make sure that sales are only made to accredited investors, and that would include, what is the issuer's process for reasonable steps to confirm accredited investor status. The due diligence should confirm what the issuer is doing to comply with Rule 506B, the bad actor disqualification provision, and Rule 506E, the provision that requires disclosure of disqualifying events that occurred before September 23rd, 2013. The due diligence will need to include confirming that such events have been disclosed and assessing the impact of events that occurred before September 23rd on the offering. Now, Rule 506D, covered persons include any person that has been or will be paid directly or indirectly remuneration for solicitation of purchasers in connection with the sales of securities. So the result of this appears to be that broker-dealers with disqualifying events could not serve as an underwriter, dealer manager, or participating broker-dealer in a 506 offering. There hasn't been a condition like that up till now. So this could have direct impact on broker-dealers who have those sorts of events and have been able to participate in offerings under 506 up till now. If a broker-dealer is a compensated solicitor, then based on Rule 506D, as I was saying, there would be bad actor disqualification of its general partner, managing member, director, executive officer, other officer participating in the offering, and was subject to disqualification. The language is so broad, any person that has been or will be paid, that it could be interpreted to also cover registered representatives of a BD that have a disqualifying event. So broker-dealers that want to participate in the sale and marketing of Rule 506 offerings need to make sure that they don't have bad actors with disqualifying events as employees or owners or associated as registered reps. At least that's my view. The other thing that should be considered in due diligence is the general solicitation and general advertising material and activity of the issuer. The broker-dealer should satisfy itself that that general solicitation and advertising material and communication is compliant with SEC and FINRA rules as part of due diligence. Moving on from due diligence, if a broker-dealer, having completed reasonable due diligence, concludes that the offering is suitable for at least some of its clients, as Rule 2111 of FINRA rules requires, then the broker-dealer needs to decide whether to sell the offering, given the additional burdens associated with reviewing and filing general solicitation and general advertising. The broker-dealer participating in a Rule 506C offering as a selling BD or a dealer manager and that is going to use that general solicitation material has to file the material as required by the advertising rule and make sure that it's compliant before the filing is made. Principal approval is required, as it is for most broker-dealer advertising of specific products. And then in addition to complying with the advertising rule requirements of FINRA rules, broker-dealers have to file new form private placement of securities form pursuant to Rule 5123 within 15 calendar days of the date of the first sale. And there are some questions that FINRA recently added to that form to try to capture whether the particular offering is a 506C offering. And if so, is there going to be general solicitation and general advertising material used? That's not a new form for 506C offerings. It was required for 506B offerings as well, but there is a new question or two on it that relates to 506C offerings. BD selling agreements with issuers or with dealer managers are likely to be changed somewhat because of this rule. Most likely they'll include new obligations related to the Rule 506 amendments, both those related to 506C offerings if the particular offering is a 506C offering, and the bad actor requirements that apply to both 506B and 506C offerings will probably drive some changes to selling agreements. Broker-dealers should consider requiring the issuer have a bond and errors and omissions insurance in case of a disqualifying event that causes the need for rescission offers to the broker-dealer's clients. As we discussed, if there is a bad actor disqualifying event, then the consequence of that is that any sales made while that disqualifying event applied to the issuer and other covered persons involved in the offering would be subject to rescission offers. So a way of helping insure against the risk of that is to require that the issuer have a bond and coverage. Broker-dealers will likely be asked by the issuer to provide third-party verification of accredited investor status in 506C offerings, particularly with respect to the status of the broker-dealer's own clients to whom the offering is being sold. As a result of the rule and other recent changes, including changes to Rule 2111, broker-dealers should review their procedures for verifying accredited investor status and suitability, make sure that they comply with the accredited investor requirements of Rule 502 and 506 and the suitability requirements of FINRA rules, and enhance procedures to achieve compliance as needed. As we mentioned a bit ago, a broker-dealer's principal would need to review and approve the general solicitation and advertising material, and it would need to be filed before use. They'd need to confirm that the material is compliant with SEC and FINRA rules and ensure that the content's fair, accurate, balanced, and not misleading or deceptive. And proposed rules would require that the issuer file the solicitation material with the SEC. Broker-dealers may want to consider monitoring rep use of Internet sites and social media associated with 506C offerings, since all of the requirements associated with 506C general solicitation would need to be met by the broker-dealer before reps start to actually use that material. And then likely clients of broker-dealers, customers of broker-dealers will have questions about various 506C offerings that the broker-dealer isn't selling. So broker-dealers should determine how they're going to respond when there are such inquiries.
Hi, this is Kate, the staff attorney with FactRight, and I'm just going to walk you through our due diligence requests for the new 506D. The due diligence requirements start with our document requests. We are requesting the engagement letter that the issuers have with their background check providers, and we are going in and spot checking those reports with our own background checks to see consistencies and if anything is missing. We also ask for any questionnaire or informal request that's to be completed by covered persons that the issuer uses to demonstrate reasonable care. Also, we request any internal documentation that states their internal procedures that demonstrate reasonable care. And in absence of any adequate existing documentation, we work with the issuer for a certification of 506D compliance. We also have a different line of questioning that we ask. We ask, has the issuer implemented any changes in their background check process due to 506D? We also look for any changes in employee relationships in light of the bad actor provision. And we look at things like how often our inquiries are updated, how often people or entities are rechecked. We look into the due diligence process issuers have on managing broker-dealers or compensated solicitors. We look at see if any contractual provisions have changed between the issuers and the managing broker-dealers. And we looked at to see if there's been changes in any ownership or voting rights of the issuers due to the bad actor provision. The line of questioning also includes things such as if what your procedure is if a covered person or compensated solicitor is become a bad actor subject to a bad actor issue during the offering stage of a program. We also asked what the procedure is now for foreign background checks. Is there one? Has it changed? Why has it changed? Did it change due to the new Rule 506D? We are just looking for ways that reasonable care that the issuer's due diligence has changed due to this procedure, new regulation. We also now always request the required 506E disclosure statement from the issuers, but then we also ask due diligence around this document. We ask that they identify the party responsible for creating that 506E document. If that party is a third party, we ask and determine if the oversight process in place ensures accuracy in that document. And again, we check that against our own background checks. We also look into the process by which the document is both maintained and updated, going back. Who maintains it? How often is it updated? How often is it reviewed and revised, etc. We also look for a disclosure document to see if the disclosure document is vetted through legal counsel, either internally or externally. How often? What do they check for? Things like that. We also look to see if any background checks were rerun during the disclosure process. Did the issuer find something they didn't know about that occurred prior to September 23rd, 2013? Just again, going back, we spot check theirs versus ours, see what process changed for the issuer, what are their procedures going forward, have they demonstrated reasonable care, are they complying with the new 506C regulations. And that ends our webinar. Thank you for joining us. This has been a webinar provided by FactRight LLC. If you have any questions, feel free to contact us. Our line is 847-805-6150. Thank you.